Recording in progress. Recording stopped.
Good morning, honorable members and the rest of the officials
Recording in progress.
of both the department and Parliament. The time is 11 o'clock, sorry. We are starting with another meeting from a 10 o'clock meeting of security and justice. And as you are aware, the pressures of time force us to meet quite frequently to deal with the business that is before us. It is on that I've just checked the roll call quickly to verify who's present in this meeting.
I think you're muted.
Oh, sorry about that. I just made a quick roll call. I said this myself. I'm sorry, and thank you very much for that, Honorable Baronhost. I indicated that it's myself, Honorable Bayer Smith, Honorable Martha Bartlett, Honorable Kenny Mutsawai, Honorable Audrey Maleka, Honorable Nokuzola Ndongeni, Honorable Rikas Badenhorst, and Honorable Shaidi Sheikh. And we are also blessed that the Deputy Minister of Copta, responsible for traditional affairs, Honorable Hans, is also part of this important meeting. In that sense, I want to say welcome, Honorable Deputy Minister, for attending this important meeting. As we are all aware, we are meeting here this morning as a follow-up to our last week's meeting, where we were considering the issue of the negotiating mandates pertaining to the Independent Municipal Demarcation Authority Bill. There was some work that needed to be done in respect of making follow-ups to the provinces that had not yet submitted their negotiating mandates. And in that sense, we thought perhaps that when we meet today, we will receive the departmental responses on the basis of those provinces that have tabled their negotiating mandates. And then we will receive a legal opinion on the request specifically made by the Western Cape and the Eastern Cape, given the pressures of time. I indicated that this bill is very, very much important. It is the heartbeat of what needs to happen at municipal level in respect of the demarcation of boundaries, municipal boundaries, as well as the delimitation of municipal wards. In that sense, this is very much important, and we need to do everything within our power to ensure that we assist the process. In case that we can't, we will have to accept the reality, but we must try our best to finalize this particular process. Now, there would be basically two presentations that we receive this morning, and based on those presentations, we would then have a discussion and a way forward about what needs to be done given the time frames that we have that are very, very tight with us. With that, Moss, can you just indicate any apologies?
Chairperson, in terms of our record, we haven't yet received any apology from the members. Thank you, Chair.
Okay. I've recorded all members who I mentioned. They are part of this meeting. Be that as it may, we are going to proceed with this meeting. We form a quorum. As I said, welcome all of you, honorable members. We are going to do item number 3, where we receive a presentation from Dr. Naidu in respect of the responses from different provinces, and thereafter we'll then get a briefing on the procedural and legal opinion on those particular requests that we made. And based on that, we'll then discuss. Yes, this is how we are going to proceed with the meeting. Can I invite Dr. Naidu to start with the presentation? Over to you, sir.
Good morning, Honorable Chair and all members of the committee. Also, greetings to the Deputy Minister, Burns Namasha. Chair, we have put together a presentation dealing with the negotiating mandates that were submitted to us. And the presentation was duly submitted to the committee. But of course, we also then received a submission relating to the negotiating mandates from the Western Cape Provincial Legislature, and those responses, Chair, are included in the latter part of the presentation. I think it numbers about 10 slides dealing with the responses responses to the Western Cape Provincial Legislature. So as part of the documents that were submitted, we had stitched together the 6 negotiating mandates that were submitted to the department. So that was submitted together with the presentation that will be made now, albeit the revisions that were included after receiving the submission from the Western Cape. So just as part of background, Chair, we thought that we'd just recollect how we have arrived here, to indicate that late last year, the National Assembly had dealt with the bill, referred it to the NCOP. We had provided a briefing to the committee on the 7th of February, and the bill was then referred to the provincial legislatures for consideration. And over the period February, March, the various provincial legislatures had dealt with public hearings as is required in terms of the Constitution, be that except for the Western Cape and the Eastern Cape province, as far as we know. And then on the 8th of March, the deliberations on the negotiating mandates of last week, and then we find ourselves here today. This slide indicates, Honorable Chair and members, the department, on request from the provincial legislatures, had supported through presentations on the bill the various hearings that were held in the various provinces. And I think as we speak today, the colleagues are also in the Limpopo province providing support to the legislature. So the next slides then deal with the actual responses to the negotiating mandates that we've received, and we deal with them province by province. The first input that was received was from the Northern Cape province. It suffice to say that the inputs that were received were general in nature and not made in respect of any specific provision of the bill. So noting communities that would be excluded, especially in the regions as indicated in the presentation, we take note of that. In relation to the next province, the Northwest Province, there were issues that were raised, for example, in relation to clause 26 of the bill, and an indication that the the bill is silent regarding the criteria used for determination and redetermination of municipal boundaries. So while we note that, we indicate that the bill already in clause 24 provides for the matters that have been raised by the provincial legislature. So it is not supported, as we believe that the matter is catered for. In relation to the third input that was received, and that was from the KwaZulu-Natal provincial legislature, there were various inputs that were made. And the first related to a request that was made in relation to clause 10.7 of the bill, and that a requirement or a request that the publication of the names of the board members as well as of committee members should also, when it is being made public after their appointments, also include their qualifications, but in order to promote greater transparency, chair and members. And we've also proposed
Dr. Naidu?
an
Dr. Naidu, I don't know whether it's only me, but you keep on cutting. And your voice is moving up and down. To an extent that some words we can't capture them
amendment
very well.
as to how. So apologies, Chair, I can't hear you.
I was saying that stand still or to a place where you are not going to cut because we're missing some words from your side.
Oh dear. All right. I think the area that I'm in needs to be, I need to move around. Is it better now, Chair?
It is better now. It's better, proceed.
Okay. All right. So I was indicating that in relation to the first proposal made by the province in relation to clause 10.7, requiring the publication also include the qualifications of board and committee members. We've supported that proposal, Chair, and we've also attempted at providing a proposed revision to the clause. But as I've indicated, we would leave that to the legal drafters, the lawyers, to deal with that revision to the bill. The next proposal was made in relation to clause 10.8 of the bill, which deals with the appointment of board members. And that was specifically in relation to the manner of filling of vacancies on the board as it would arise after the board was established. So, for example, in the bill, we provide that the long list that would be submitted to the president for consideration, that should be revisited in the event that a vacancy arises. But the proposal from the province was that there should be a time frame attached to that. We've considered it, and we've indicated that we do not support the inclusion or the revision of that specific provision to the bill for the reasons set out on the extreme right of the column that is before us. And perhaps to summarize it, to say that we should leave the prerogative or the responsibility of the consideration of the long list by the minister. So the minister can either consider it, taking into consideration the time that has lapsed for the board that has been in place, or the time that is left for that board to serve its term of office. The next clause deals with clause 38 and a requirement or a proposal from the province indicating that a more comprehensive process in relation to the appointment of the appeals authority, similar to the way in which the board is appointed. And we have not accepted or not supported the proposal being made by the province and indicated that there needs to be a clear identity for the two authorities and the way that they are appointed. Our research has indicated that that process in which we have proposed in the bill as it is aligned to the way in which other tribunals are appointed. And I think if our memory serves me correct, it is the Consumer Tribunal that we had looked at, which is aligned to the manner in which we have proposed in the bill that we have. The fourth province was Gauteng, and there were quite a few proposals made by the provincial legislature. The first being that in relation to clause 8.2 of the bill, which deals with the responsibilities of the board, they make a proposal that suggests an inclusion of provisions to say that the board would act independently at all times, exercise independent judgment, etc. We believe that that proposal is adequately taken care of in the present provisions in the bill, which indicates in clause 4 that the authority must be independent, impartial, and perform its functions without fear, favor, or prejudice. And I think to a large extent, this is the language or the formulation that is used for other similar such institutions. In relation to clause 16.3, and which deals specifically with provinces, the proposal was that the criteria and qualifications for the co-opted members be specified. We have supported the inclusion or a revision of this specific provision in the legislation, and we would therefore rely on the lawyers to deal with the revisions to that specific provision. And I think it largely aligns to the previous or to the proposal made by a previous legislature that was already presented. Clause 16.4, Gauteng province legislature suggested that there should be a limitation on the number of members that can be co-opted. We have not supported that, and we've indicated that the legislation provides for the board to determine its own rules and procedures, and we believe through that provision it could be dealt with in terms of limiting the number of members that can be co-opted. Clause 26, a proposal was made in relation to the initiation or the determination of municipal boundaries, that the term of office of the Demarcation Board and the time frame for considering the redetermination of municipal boundaries, the 5 years versus 10 years, should be considered, as this could cause administrative challenges, as two separate boards will then be responsible for considering redeterminations of boundaries. We've noted that, and we believe that in the provisions that we have introduced already in the bill, that the matter has been dealt with through the alignment of the term of office of the board to the alignment of the term of municipal council. So as we've indicated in our previous briefing, that you would have a single board that would be responsible for determining outer boundaries, as well as to look at the delimitation of inner boundaries of a municipality. The next provision from the province related to clause 40, dealing with the qualifications of members of the appeals authority, and specifically indicating that the appointment of the board is too restrictive because ordinary citizens are not given a chance to be on the board. We have not supported that, and we believe that the present provisions in the bill offers an equal opportunity for the appointment of the chairperson and other members of the appeals authority to collectively represent a broad section of the population of the Republic. And as I've indicated a little earlier, that the process in which we have included, or the provisions that we've included in relation to the appointment of the appeals authority is aligned to the provisions that relate to other similar institutions / tribunals. The sixth submission made by the province related to Section 41 of Act number 27 of 1998. We've highlighted it in yellow to indicate that the submission or the input was not in relation to the specific bill, but in relation to the legislation that we have in force presently. The proposal was that it is recommended that 3-year budgets are provided by the National Treasury for such mergers, and that the National Treasury should continue to monitor and, where needed, support such municipalities, be provided with such support beyond the 3-year transitional period. Thirdly, when merging municipalities, the board does not take note of the financial viability of the municipalities. We have noted that, and we believe that the provisions as it is provided for in the bill requires the board to consider various factors, including financial and the administrative viability of municipalities. But secondly, or in addition to that, the introduction of the 10-year cycle for the determination or redetermination of major boundaries intends to limit the challenges associated with amalgamations, as was done in the 2016 amalgamations that we've had across the country, or at least I think in at least 5 of the provinces. The National Treasury had provided for transitional costs for the redetermination of municipalities, and that was informed by inputs, interaction, engagements with affected municipalities, but also with the affected provinces. We also believe that Clause 24C of the bill specifically compels the board, when determining or redetermining boundaries, to take into account the financial viability and administrative capacity of the municipality to perform functions effectively. The 7th submission was in relation to Clause 26, and it was submitted by the province that, in line with municipal boundary redetermination, it is proposed that ward delimitations should be done after 10 years. Now, as indicated in previous submissions, that this could be problematic, especially trying to comply with the Constitution, because not just in 10 years, but from time to time, we have migration and population changes within a ward, within a municipality, and it therefore becomes necessary for the authority to undertake ward delimitation within a 5-year cycle. Of course, one must also have regard to the legislative provisions that relate to the way in which the norm within a ward needs to comply within the 15% change. And if it is beyond that, certainly if you leave ward delimitation to an extended period, that 15% norm would not be adhered to, and therefore the authority could be finding itself wanting for not having complied with that legislative provision. The 8th input was in relation to Clause 47 of the bill, which deals with municipal capacity assessments. And the province had indicated that while the inclusion of capacity assessment is welcomed, the bill does not go far enough in ensuring that capacity assessments are well defined. To this end, it is recommended that the authority, the department, and the provinces to develop guidelines for conducting capacity assessments. We have noted that, Honourable Chair and members of the committee, and have indicated that the bill provides for the Minister to prescribe any regulations incidental to the Act. The indicators, criteria, and other factors to be taken into consideration by the board when conducting capacity assessments will be considered when regulations in relation to this specific matter will be dealt with. A general comment made was that a provincial representation of provincial offices as opposed to a centralized national office. We have noted that, and we believe that it is already catered for in clause 6 of the bill, which requires or impresses upon the authority to do all that is necessary or expedient to perform its functions effectively. Of course, this would have financial implications in terms of decentralization of the national office. There have been, Chair, in the past attempts to deal with this provincialization of the authority or the board. And of course, this would require interaction, engagement with the National Treasury, and of course, resources permitting a business case being presented would ultimately indicate or guide as to how that provincialization would be required. How will the bill affect the traditional royal house? The bill already, we believe, makes sufficient provision for consultation of the traditional and Khoisan leaders at all levels, and that also areas of traditional rural communities are also amongst the factors to be taken into consideration when determining and redetermining municipal boundaries. The fifth input, provincial input, was from the Mpumalanga Provincial Legislature. And the first input that was made was in relation to clause 5, 727, relating to, in the main, the House of Traditional Leaders, indicating that the provisions, clauses 5, 7, 26, and 27, and that the composition of people who must serve in the authority should be people who understand the nature of demographics in the areas in which they reside, especially in rural areas. We believe that the clause or the proposal has been adequately catered for in clause 27 of the bill, which makes provision for consultation of traditional and Khoisan communities at all levels. In relation to the second input made by the province, that relates to clause 38, specifically around the establishment and the constitution of appeals, but also indicating that there should be a determination of time or a time frame for the handling of each appeal case. Now, when you look at section 43 of the bill, it firstly indicates that at the instance of a boundary determination being settled or finalized by the board, within 30 days thereof, an aggrieved person or community needs to raise the matter with the appeals authority. When you go to section clause 43(5) of the bill, it indicates that once the authority receives such representation, it needs to be settled within 30 days after receipt of the. So we believe that by virtue of those provisions in the bill, the matter is adequately catered for. The third input made by the province relates to clause 10, and that was specifically around the appointment of board members, and it has been indicated that the clause does not leave much room for the appointment of independent members of the board, and that except for the convener being the Constitutional Court judge, and the appointment of the chairperson of the Commission for Gender Equality, all the other appointments are laced with political connection, and that's the language that has been used, which we have imported into the presentation. A similar comment was made in number 4 on the slide that we have before us. We have noted that, and we've indicated that the composition of the selection panel goes far beyond just the representation of MPs. And Honorable Chair, having been part of the processes from the very first board that was appointed in 1998 to the most recent one, I can indicate that the process of appointing board members is a thoroughly considered process in terms of the ultimate appointments that are made by the president. The first submission by the province was in relation to the finances of the authority and how the board will address the unique challenge of lack of resources. We believe that the present provisions as provided for in clause 22 deals with this matter. The sixth submission was that the demarcation should go through verification through consultation with the House of Traditional Leaders. We believe here too that the matter is catered for in the bill that we have. The sixth and the second last provincial legislature input was from the Free State. The first submission being made that in clause 10, that the bill must also designate a percentage of the board to the people living with disabilities. And we've indicated that we've noted it, and that the selection panel, when considering the manner in which they would appoint board members, should include this as part of its decision-making procedure. Clause 10, the second input, dealt with the bill dealing directly that advertisements for the nominations must be made such that they are also reach people who don't have access to mainstream media. And we've also noted that, and that accessible media platforms for publication of the advertisements are already used and catered for in the bill. In relation to the appointment of board members, that individuals being considered be subjected to screening in a vetting process. Although this is practice when appointing board members, we have supported it to be included as part of the legislation, and we've also proposed a reformulation of the drafting there. Of course, that would be considered by the drafting team, but noting that we have supported the inclusion of that specific provision in the bill. In relation to clause 24, which deals with the factors to be taken into account when determining boundaries, the proposal was that the redetermination of boards must take into account the geographic, economic, and social factors, amongst others. We've noted that, but we believe that it is already catered for in clause 24 of the bill, which is an import of Schedule 1 of the Municipal Structures Act. In clause 38, it is submitted that the appeals authority must be accessible and their contacts thereof be made available. We've noted it, and we believe that that matter can be provided for in regulations if it is not a matter that would be considered already in terms of the board indicating on their website, for example, that these are the constitution of the appeals authority. The sixth proposal was that the 10-year period for ward delimitation is proposed, and for as previously indicated that the matter is not supported, and that we could be running into constitutional problems if we do extend the 5-year period to a 10-year period for ward delimitation. The next submission by the province was that the authority must undertake physical verification before what changes are made. We've noted it and we have not supported it, noting that we have presently close to 5,000 wards across the 257 municipalities, or minus the districts, and that we believe that the bill requires the board to delimit municipalities into wards, taking into account, amongst others, topography and physical characteristics. And we believe that technology is available to get to close as conducting physical verification. Lastly, generally, the authority must have provincial officers and provincial representatives thereof. And I think the matter has already been responded to in a previous submission made by by another provincial legislature. Honorable Chair, these are the additions that we've made overnight from the submission that was received from the Western Cape Provincial Legislature yesterday. So firstly, a general comment or comments that were made by the provincial legislature, indicating firstly that the bill maintains the long-standing proposal for a 10-year interval for boundary redetermination. But it goes further to say that this will assist to address the governance and financial sustainability challenges resulting from frequent changes. Perhaps to say to the committee to note this, but also to reflect on it when we come to the second last or third last slide that refers back to the 10-year interval that the provincial legislature had made. Secondly, that the bill addresses the impact of a lack of presence of a provincial authority. We've noted it, but also responded to it in previous remarks that have just been made. That the bill eases up the appeals load by providing for provincial appeals authorities. The same would be applicable in relation to the response provided to decentralization and provincialization, as indicated in previous remarks. The bill provides for the creation of a transitional grant, and as I've indicated earlier, in the previous amalgamations, notably undertaken in 2016, it was the prerogative or the responsibility of the National Treasury, in consultation with the National Department responsible for local government, provincial COCTAs, as well as affected municipalities, that informed the creation of a transitional grant. That what the bill proposes on strengthening communication and consultation is sufficient and grounded in practical and meaningful interactions. Those were comments we've noted. But then specifically a proposal around providing in clause 1, which deals with definitions, to insert a definition for president. We have accepted that, we support that, and we've provided a formulation for consideration by the drafting team as the bill is revised. In relation to the second input that was made by the province, by the provincial legislature, and in relation to the composition of the board specifically, and that more emphasis should be placed on gender, as we have responded in relation to the disability issue, we believe that the selection panel to consider this as part of its decision-making procedure. Clause 8, a similar proposal was made, and if my memory serves me correctly, I think it was the Gauteng province. We believe that this is adequately contained, provided for in the bill that we have presently, and as catered for in clause 4. I will not repeat it as we have done so already. Clause 9.2 specifically around the qualifications of board members, and it is recommended that 9.2e should be amended to include persons that hold positions in a party political office. We have not accepted or supported that provision for the inclusion thereof, as we believe that the bill already covers those positions with political influence. The next proposal was made in relation to clause 10.1b, which specifically deals with the appointment of board members, and the proposal that the composition of the selection panel in clause 10.1b presents potential political influence. Honorable Chair, we have responded to this in previous remarks, but also in the presentation itself. In relation to clause 10.3 and the appointment of board members, it is a concern that the selection panel may determine its own procedures. We have noted it, and we've indicated that while the selection panel may do so, such procedure must be fair and transparent as contemplated in clause 10.3 of the bill. In relation to clause 10.8a, the submission was made that it is a concern that the default position for filling a vacancy on the board is to require the president to fill the vacancy from the additional names, and I've referred to it in my previous remarks as the long list. It is recommended that any vacancy on the board be re-advertised and that the process outlined in this section be followed. We have not supported this for the reasons set out there, and we believe that while there is the option of considering the long list that was submitted, there is also the option of not considering it and to rely on restarting or redoing the entire process of filling of vacancies or that which is required when establishing the board. In relation to clause 11.4, the provision, the submission was that members of the board are appointed on a part-time basis, and therefore the framing thereof may be superfluous, and it may not necessarily be required that we have it formulated in the way that we do. We have noted it, and we will engage with the legal drafters to ensure that any reformulation that would be done is explicit, but to also indicate that the minister would have the prerogative to exercise her responsibilities in relation to part-time and full-time members of the board. In relation to committees, it is a concern the provincial legislature has indicated that there is no limitation on how many committees the board can appoint to assist with the performance of its functions. And there is a reformulation that is provided or proposed, which we have not supported, and we believe that section 15 or clause 15 of the bill does deal with the matter relating to committees, the number and the composition of such. Clause 16.3 deals also then with committees, and it is submitted by the provincial legislature that the criteria and the qualifications for the co-opted members are not specified, but as was proposed by another provincial legislature, we have considered it, we've supported it, and the necessary revisions will be made to accommodate the proposal being made. Still on committees, and with no limits provided up front for the co-option of members, there is a concern that this would be opening up an avenue to create a board within a board. Here too, we have not supported the submission or the proposal, as we believe that section 15 of the bill adequately provides for this matter. In relation to clause 19.3b, which deals with the chief executive officer of the entity, the proposal was that the clause refers to seconded. However, there is no reference to the legal authorization of such secondment. And that a proposal is made in relation to the Public Administration Management Act, and that a definition can be incorporated under clause 1, which deals with definitions. We have noted this, and we've indicated that the conditions of employment of employees, including secondment, is broadly covered in clause 20 of the bill. Clause 24 deals with the factors to be taken into account, and it is indicated or submitted by the legislature that the factors set out in clause 24 are supported, but they need to be more careful identification and elaboration. It goes further to say that it should provide specifically for bulk service provision, for water catchment and service areas, etc. We have not supported that for the reasons set out in the extreme right, and we've indicated that the bill already encompasses a comprehensive list of factors to be taken into consideration, which are provided for in clauses 23 and 24 of the bill, which includes the need to rationalize municipalities and the consideration of different types to achieve the objectives of effective and sustainable service delivery. The next submission was made in relation to clause 25.3 of the bill, and a proposal that consideration should be given to the inclusion of more measurable indicators, especially in relation to the determination of category A municipalities, as it is too broad and it cites the different provisions or sub-provisions in that specific clause of the bill. And it is recommended that the work done by the CSIR around the South African functional town typology be considered, etc. We have noted that, Honorable Chair and members of the committee, and we say that while that may not be our only consideration, because there are other policy imperatives and initiatives out there, notably around the small town regeneration strategy, around the integrated urban development framework. Those could also be, matters that could be considered to inform the determination and establishment of different types of municipalities. We've therefore noted it and indicated that could consider such in the development of regulations to complement the implementation of the Act. Clause 26 deals with the initiation and determination of boundaries, and it is proposed that the board may only determine or redetermine a municipal boundary every 10 years. So although the provision attached to the time frame is associated with the movement of more than one ward, more than one whole ward, it is not clear how the period of 10 years was determined. In noting that, we've indicated that the 10 years is informed by the two terms that would make up the 10 years, and the two terms meaning the 5-year term each of the term of a local government. So also, when you look at the middle column and the second paragraph there, the time frame raises questions, especially in the context of the fact that many municipalities are experiencing challenges to meet their constitutional delegations, which results in poor or no service delivery to their local communities, and that it is an extremely long time. So one would need to see the benefits of this that the legislature had made in its general comments, which I went through at the beginning of this part of the presentation. So the benefits being sustainability, and stability, as was mentioned in the submission made. The 16th provision or proposal that came from the legislature dealt with clause 29 and public consultation, and the proposal that the consultative meetings for redeterminations should include a provision for an interpreter to address the vernacular needs of the public in the region. We have accepted that, we supported it, and of course the necessary revisions would be made to the legislation to provide for this proposal. In relation to clause 32 of the bill, and when municipal boundary redetermination takes effect, to omit the words after May and to provide in exceptional cases, etc. We have not supported it, and we've indicated that the minister may decide on a different or shorter period on exceptional cases. Public participation in the delimitation of boards. The clause provides for public consultation in the delimitation of wards to be conducted by the authority, and it would be recommended for the purposes of clarifying responsibilities that there are clear provisions that relate to the costs associated with these consultations, such as venue hire, interpreting services, etc. We have noted it, we have not supported it, as we believe that the board is listed as a constitutional institution and that it already makes use of available facilities and resources from other state institutions, most notably municipalities. The next dealt with the establishment and the constitution of the appeals authority. And it is suggested that the current appointment process is inadequate. At present, the minister is empowered to draw up a list of names for the president to appoint from in response to a call for nominations. We've noted it, we've already responded to it in the remarks made already, that the process that we have provided for in the bill is aligned to the way in which other tribunals are established, but it's also a matter that we could consider for inclusion in regulations to complement the implementation of the Act. The next submission was made in relation to transitional arrangements, and it is indicated that it would not be possible to perform any functions or give effect to the Act that is presently in force, as the intention of the bill is to repeal the Municipal Demarcation Act. Therefore, the transitional arrangements as they currently stand should be revised so as to make enforceable the current actions of the board when the bill does take effect. We've noted this, and this will be discussed together with our legal drafters and the legal advisors as the bill is being finalized. Honorable Chair and members of the committee, to thank you for your attention. It's been a long presentation, but we ask that the committee note the contents of the presentation that we've made, responding to the 7 inputs that we have received in the negotiating mandates that were submitted by the provincial legislature. Thank you very much, and I will pause here.
Thank you very much, Dr. Naidu. Yes, it was a long presentation, but very necessary and informative. Informative in a sense that it reflects the views, proposals, and concerns of provinces, especially after they engaged in public participation processes. That shows that this was meaningful and people did make their contributions in terms of what they want to be included or excluded in the bill, and how we must secure improvements in respect of this particular bill. I think, yes, it was quite necessary that we hear that. Before we proceed to the legal opinion, can I verify this and confirm this to you? Under the circumstances, it is only the Eastern Cape and Limpopo that have not submitted their inputs, negotiating mandates. Is that correct? Is that the understanding?
Yes,
you, Dr.
yes, Honorable Chair, that is correct. We have not received those two submissions. Thank you.
Yes, and Limpopo was saying they will submit them before the 24th of March, right?
My team tells me that they will be submitting tomorrow, Honorable Chair.
Tomorrow. The Eastern Cape, I tried to reach the chairperson of the Eastern Cape, but I failed. I couldn't get hold of the chairperson. Any feedback from them?
We have not received any word, Honorable Chair.
Yes, as matters stand, we have the negotiating mandates from the 7 provinces, and 2 outstanding provinces we haven't received. Okay, that's understandable. Can we then, based on this, obtain a legal opinion, especially in respect of the procedure from our legal section in Parliament?
Sorry to interrupt you. Are we going to deliberate this report now or afterwards?
Yeah, let's deliberate after we receive the report, so that
Thank you, Chief.
we weigh them together at the same time. I think it is quite proper that we do that.
Thank you, Chief.
We'll go province per province in respect of our based on what we receive as our legal opinion, and after having assessed it, we'll then go province per province. Over to you, a person designated from Parliament, legal team.
Morning, Honorable Chairperson, Honorable members, and to my colleagues as well. I'm not sure, Chairperson, if I'm audible. Am I audible?
Yes, you are audible. I can hear you.
Chairperson, may I ask through you, Chair, that I switch off my video, because I'm afraid that I might be on a collision course with my bandwidth.
Okay, no, it's okay. It's okay. As long as we have seen you. Yeah.
Okay, thank you, Chairperson. Chairperson, you will recall that you solicited legal advice on the request for an extension of the timeline for the tabling of provinces negotiating mandates on the IMDA bill. Now, the legal question being whether there are persuasive and lawful grounds for the committee to grant such a request or requests, particularly from the Limpopo Legislature, the Eastern Cape Provincial Legislature, and of course, Chair, won't count the Western Cape because we received its negotiating mandate. Now, Chair, as you may be aware, Chairperson, the mandate of Parliament is three-pronged. And of course, when I speak about Parliament, Chair, I speak about the NA and the NCOP as well. So the first thing, Chair, the first mandate of Parliament is to make laws. And of course, the second one is to facilitate public involvement in the legislative and other processes of it and its committee. And Chairperson, if you look at section 72, subsection 1, the language that is used there, Chair, is very peremptory. In other words, it is final and absolute. It says the NCOP must facilitate public involvement in the legislative and other processes of the council and its committees. Now, the last one, Chair, being that Parliament exercises oversight over the executive. Now, Chair, in your opening remarks, Chair, you pointed us to the strategic importance of the subject bill or the bill that is before us. And Chairperson, there is no denying that the bill in question deals with matters of strategic importance, namely the establishment of the IMDA, and sets the criteria and procedures for determination or determination of municipal boundaries and delimitation of wards by the authority. So the bill has a direct impact on municipalities. And given the nature, scope, and possible impact of the bill, it will most likely require an extensive public participation process. Chairperson, if you go to the NCOP rules, the 10th edition, particularly Rule 219, the rule reads as follows, Chairperson. All sections 73, 76, 3, 4, 5, and 7, all sections 70, 76, 3, 76, 4, 76, 5 bills must be dealt with in a manner that will ensure that provincial legislatures have sufficient time to consider the bill, facilitate public involvement in the processing of the bill, and confer authority on the provincial delegation to negotiate and vote on the bill. Now, subsection 2 says, sub-rule 2, depending on the substance of the bill, the period for the consideration of the bill is at least 8 weeks. Sub-rule 3 says, in the event that the substance of the bill requires more time than the 8-week period, the committee, the chairperson of the council may, at the request of the chairperson of the relevant committee or speaker of a provincial legislature, extend the period. So that's the rule, Chairperson. Now, Chair, will say that the NA, the NCOP, and provincial legislatures each have a constitutional obligation to facilitate public involvement in their legislative processes, and their obligations to facilitate public participation are contained respectively in sections 59(1)(a), 72(1)(a), and 118(1)(a) of the Constitution. And of course, Chair, public participation is a crucial part of participatory democracy and the lawmaking process, as it affords the public a meaningful opportunity to participate in the legislative process and strengthens the legitimacy of legislation in the eyes of the people. Now, Chairperson, we have cited various judgments, Chair, and I'm not going to read word for word, but we've taken some of the most salient features, one of which being the system of democracy established by the Constitution is partly representative and partly participative in character. And this would take, Chair, from the Matatiele municipality judgment. The Constitution contemplates that the people will have a voice in the legislative organs of the state, not only through elected representatives, but also through participation in the lawmaking process. And as you may be aware, Chair, Doctors for Life is the seminal authority for the principle that legislation can be declared invalid for lack of public participation in the lawmaking process. Now, Chairperson, if I may quote just one paragraph, Chair, in Doctors for Life. It says, in our account, the right to political participation is given effect not only through the political rights guaranteed in Section 19 of the Bill of Rights, as supported by the right to freedom of expression, but also by imposing a constitutional obligation on legislatures to facilitate public participation in lawmaking process. Chair, I'm not going to preach to the converted, Chair, because everything that I've said is what the honorable members are aware of already. But Chair, I think the point to be made is that in Doctors for Life, the court said the saving of money and time in itself does not justify inadequate opportunities for public involvement. And Chair, one of the points that was made, Chair, in the recent judgment, which is the Mohale judgment, Chair, was that regardless of the process Parliament chooses to adopt, it must ensure that a reasonable opportunity is offered to members of the public and all interested parties to know about the issues and to have an adequate say. And it continues, and it says a reasonable opportunity to participate in legislative affairs must be an opportunity capable of influencing the decision to be taken. Shall we say that Limpopo has requested 2 weeks, and of course, my colleague from COCTA has said it seems as if they will be submitting their negotiating mandate tomorrow. And of course, as we have said, with the Eastern Cape, we seem to not know where we are. But in terms of the submission they wrote, they simply said that from now up until the 31st of March, there are matters that they are seized with, and of course, I think they will only be able to deal with that after that period. Chairperson, we say that there can be no denying that the substance of the subject bill, and I think that's exactly what you said, even in your opening remarks, is of strategic importance as chief amongst its purpose, Chair, is the question of delimitation of wards, determination and redetermination of municipal boundaries. We say, Chair, we should heed the recent judgment of the Constitutional Court in Mohale, Chair, where it said the obligation to facilitate public involvement rests independently on both the NCOP under Section 72 and provincial legislatures under Section 118 of the Constitution. The provincial hearings are part of the NCOP process, and any shortcomings in the process of the provincial legislatures fall to be imputed to the NCOP. Chair, we say the two provinces have said it themselves that the timeline given by the Select Committee is too short for the said provinces to facilitate adequate public involvement and consultation. Accordingly, Chair, we say the requests by the respective provinces for an extension of timeline for the provinces negotiating mandates should be granted. And we say, Chair, unreasonably withholding the said requests has the real danger of opening up Parliament to unnecessary and costly litigation, and this will place Parliament on a collision course with the current jurisprudence, particularly on the centrality of adequate public involvement and consultation in Parliament's lawmaking process. We advise accordingly, Chair. For now, Chairperson, I won't go further than that. Thank you very much.
I can't hear anything. Is there anybody else?
Yes, we are here, Chair. Moss, could you just verify where the Chair is?
Yes, I'm here.
Okay.
I got cut. I don't know what happened. But it was at a point where the presenter was emphasizing the need that we must ensure meaningful participation and the fact that this bill is of a strategic nature and we must look at it from that particular context. I'm not sure what did I miss other than that. Honorable Sheikh, did I miss any other thing before I proceed?
And no, I think you covered it, Chair.
Yes, I cut for about 30 seconds and I tried to come back immediately. I don't know what happened. Be that as it may, thank you very much as well for the presentation. Now, honorable members, some few things. One is that this bill, as I indicated, is very much important. As the presentation indicated this morning, the National Assembly finished or pass the bill on the 30th of November and refer it to the NCOP. And when they passed it, it was the last day before they went on recess. The first meeting, we gave this bill a priority. The first meeting on the 7th of February, when we opened, even before Parliament opened, we received a presentation from the department, and immediately we sent this to provinces the same day, because we attach urgency to it. And provinces are expected to do their work as well within the necessary time frame. And as the presentation indicated, within the 8-week cycle, the provinces are expected to do that. Now, where we are at the stage in terms of this, we have received 7 negotiating mandates from provinces. The outstanding is Eastern Cape and Limpopo. I feel that they are holding us at ransom. I feel that they are delaying us. I feel that whatever decision that we want to make in this particular instance, it must not frustrate this process. This process must not be frustrated by 2 provinces. It can be correct. Because if we are going to leave this, it will have profound negative implications for the country as a whole, in fact. Because this bill is very much important. Within the next 2 years, there would be municipal elections. And the basis of these elections will be on this bill. And if we are to allow the new parliament and not finalize this, it means that they have a choice to continue or to restart the process. If they choose to restart the process, it is a long, protracted process again. And we need to discuss along these lines and say, under the circumstances, what do we do? I'm going to open this for discussion, I see the hand of Dr. Naidu before Honorable speak. Dr. Naidu, do you want to say something?
Yes, thank you very much, Honorable Chair. I just wanted to make a correction. I indicated that the Limpopo Provincial Legislature would be submitting their negotiating mandates by tomorrow. It's actually, Chair, that the province will be having public hearings tomorrow, which we will be supporting, but not that they would be submitting their mandates tomorrow. Just my error, and trying to correct that, Chair. Thank you.
Okay, thank you very much for that. Let me open the discussions for members. And I propose that the discussion must follow this pattern. To say, here we are, where we have received the negotiating mandate. We all know that after this negotiating mandate, after engaging with the responses from the departments, we will be referring this back to provinces for their final mandates. And maybe at some point we need to get an advice in terms of, if we are to do that, what implications will this have to the whole process, and the fact that Parliament must go on recess, or it must retire in relation to this process as a whole. Can I open discussions? I note Honorable Bayer Smith. You will be number 1. Number 2 will be Honorable Shaida Sheikh. And then number 3 will be Honorable Badenhorst. Yeah, let me take the first 3 hands and take it from there. In that order?
Thank you, Chairperson. Am I audible?
Very, very much so.
Thank you very much. Chairperson, there's a few things that concern me. The first one is, in Afrikaans we say, there's a saying that says die wa voor die osse span. And it translates to putting the wagon in front of the oxes. the fact that we've done the negotiating mandates before getting the legal opinion concerns me, because it should have been the other way around, and then it can direct us going forward. So that is the first thing that flags for me. Jay, the matter of the fact is, if we look even at the Western Cape that submitted their negotiating mandate, they made it quite clear that they were under a lot of pressure to submit that negotiating mandate without being able to do proper public participation. And they just pushed to at least have an opinion in, because they felt that they will be left behind. But that is not proper, as you said, and you said in every single meeting as the chairperson, that this bill is extremely important, and it got significant implications. And the courts have clearly said before, if a bill like this that has got extreme influence or impact going forward, it should have even more public participation to make sure that everybody's view are included. And I am concerned that we are pushing, because we are under pressure. The provinces are under pressure. They have indicated very clearly that they are bombarded with a lot of legislation that they have to do public participation at once, and they cannot keep up. So, Chairperson, I really want to urge that this committee considers giving the proper extension so that the provinces can do proper public participation. Because you indicated now that if it's left for the next parliament and they restart, it's going to be a long process. Now, if we don't do the process proper, it will be referred back, and we will have to do that over again in any way. So I want to urge that we please follow the path of giving extension, giving provinces the opportunity to do proper public participation and do that. Our program in any way is running until the 21st of May. So we have got an opportunity to still deal with this. So that is my submission, Chair, and I really hope that we will not see that we are being kept ransom by provinces, but rather that provinces are putting the interests of their communities in their province first, and making sure that they have their say within this bill. Thank you, Chair.
Thank you, Honorable Sheikh.
Thank you very much, Chairperson. And let me just thank both the department and legal services for the presentations that they made. Chairperson, the first point I wanted to make, I think Mr. Naidu had covered me because he had said that you would receive negotiating mandates from Limpopo tomorrow, but he clarified that because they're busy with public participation tomorrow. But also to remind you, Chair, that Limpopo had requested for a 2-week extension on this matter. So I would imagine by next week, the negotiating mandate from Limpopo would be provided to the committee. Chairperson, I just wanted to raise another issue, especially in relation to the legal opinion around providing an extension. And Chair, I think you've summarized it very well in terms of the importance of this piece of legislation and the fact that it would be important for us to try and finalize this process in this term of Parliament rather than defer it to the next term of Parliament, given the time that is required before local government election, especially to deal with redetermination of boundary issues. And even that in itself has quite protracted public participation processes. We can recall that when the redetermination processes, when communities are unhappy with that, that leads to a lot of protests. It also leads to a lot of unhappiness, and it can even affect local government elections within these affected areas. And I think we've seen that in the past. So obviously, the ensuring that this piece of legislation is passed within this term of Parliament, and the importance of this piece of legislation it's important that we can't have an open-ended kind of extension on this legislation, because when I even look at the request that came through from legal services, it's that we should allow for an extension. And I would want to ask legal services, obviously, given the fact of the importance of the bill and ensuring that we try and procedurally finalize it in this term of Parliament, obviously, like I said, it can't be open-ended. So obviously there has to be a cutoff period. So even a province might ask for an even lengthier period of time. But obviously you have to take certain things into consideration. And as a committee, we'd have to agree that if we need to do an extension, we'll have to have that cutoff period. So it can't be open-ended. And I want legal to also comment on that, especially given the fact that the request for extension, some of it like tries to extend it even further. But obviously these are considerations that I have to consider as a committee. But legal, if you could maybe comment on that. But the second thing, Chair, that I mean, obviously, I shouldn't take away the fact, Chairperson, in our last meeting, we spoke about ensuring public participation and that it is important in the legislative making process. So, I mean, obviously, we would want to consider this issue very, very carefully. But also what I would want to know from legal, that even though we have a piece of legislation that has, based on the factors of that legislation, the importance of that legislation, that we need to try and deal with it within a specific time. But if there's a province that does not want to commit to that period of time, I mean, then what happens in such a situation would be another question. And also linking to this, within the rules of the NCOP, where you need 5 provinces to pass a piece of legislation, if they can maybe give some comments on that. Chairperson, in terms of the presentation by the department with regard to the proposals that came from the 7 provinces, Chairperson, obviously we note that, but from my side, especially from the side of Limpopo, obviously we would want to also see the Limpopo negotiating mandate being responded to by the department, and thereafter, Chair, we'd like to then also engage in this discussion. Thank you very much, Chairperson.
Thank you very much, Honorable Sheikh. Honorable Badenhorst.
Thank you very much for the opportunity. I've been partly covered by Honorable Smith. I just wanted to clarify procedurally. I've heard references that the Western Cape negotiating mandate was submitted late. I've submitted in the chat. I have in my hands the email that was sent from the Western Cape Provincial Parliament to the administration that the negotiating mandate was submitted on the 7th of March. So I don't know where the reference comes from that it was submitted late, but maybe we can just correct the record for that procedural aspect. If I may then, Chair, just to go on to the rest of the debate, I think we need to make sure, as the NCOP, that we follow the Constitution. And Section 72 of the Constitution says that we must facilitate public involvement. So we don't have a choice. We have to provide it. And then our own rules, Rule 219, is very clear on how we have to provide that public participation platform. And it says at least 8 weeks. So that's the bare minimum. Now, if you're going to get a briefing from the department to the province on, for example, in the Western Cape on the 13th of February, 8 weeks from that takes it to the middle of April. That's the bare minimum. But I have to hasten to add that when the Western Cape submitted their negotiating mandate on the 7th, they also, on the 7th of March, they also submitted a letter from our speaker to Honorable Masondu, the chair of the NCOP, to bring under the attention of this House that the Western Cape had very little time to go through a proper public participation process. They had to resort given the time frame, to social media just to get comments from the public. Now how many people have access to social media? How can that be proper public participation? So we have a problem in the sense that you also mentioned more than once how important this bill is. So we have a problem in the sense that we haven't given enough time for public participation. And if this ever gets tested in court, which I'm sure it will, we're going to have a problem anyway. So we need to take that into cognizance before we now decide we're going to take the negotiating mandates from 5 provinces and barrel this through, because we will have an issue afterwards. Thank you, Chair.
On members, before I invite the legal people to respond to the questions in terms of the implications of the time frames, I want to really make this point. Firstly, we are all under pressure, all of us, provinces and the NCOP and the National Assembly. Just this year, I've attended many sessions in Parliament, whether it's chairpersons of committees, whether it's whips of committees, and in all the platforms where we were asked to prioritize the legislation that must go through before the end of this parliamentary session. And we had to state quite clearly the reasons why we prioritized this and that legislation, and why we were not going to proceed with other legislation. We have done that. And this legislation, this bill that is before us, is one of the priority bills. And we are all under pressure. There's no question about it. The elections are just around the corner. But the question as members of parliament we must ask ourselves is, what do we do under the circumstances? Given the fact that we must prioritize, we must make sure that whatever that we do, we incorporate the element of public participation. That must be meaningful. That's what we have said. Now, I said, as members of parliament make contributions, they must bear one thing in mind. 7 provinces have undertaken this process, and the way they did it differs from province to province. Honorable Badenhorst has just given his own experience about the Western Cape. There could be other experiences with all the provinces. What did they do? But no province has said to us, this was not meaningful, this was conquer, this was just rubber stamping. Formally so to us. But what provinces have done, they've raised their own concerns to say, we are really under pressure, which is understandable. Now, all of us as members of parliament, we mustn't act as if we say we want to pass the legislation at all costs, and in doing so, we neglect meaningful participation. Because of course, if we do so, if we neglect it, this law that we pass will not pass constitutional muster. It will be referred back to us. And where I see it, I'm at the point where I say there are 2 provinces that, irrespective of the time, irrespective of everything, irrespective of the challenges that are quite similar throughout the provinces, that we are left with 2 provinces, the Eastern Cape and Limpopo, that have not submitted their negotiating mandates. We are left with 2 provinces. And under the circumstances, we must answer that question. The question is, what do we do? What do we do under the circumstances to ensure that we move forward? And I'm saying this wholeheartedly, if it is not going to be possible, we'll accept that it is not going to be possible. But where I see it, I think this is possible. And maybe legal must also answer that question, that if we have 7 provinces that have responded and 2 provinces have not submitted their negotiating mandates, what do we do? Part of it could be that we have a 2-week extension or a week extension so that we receive that. And if we fail to receive that, how do we proceed forward? My honest view is that we, in the interest of saving our country, we must do everything legally and constitutionally. We must try our best under the circumstances, and we must make sure that at the end of the day, this law is passed by Parliament. If we do so, we save a lot of things, a lot of processes that will have huge implications for this country. We all know that the demarcation and redemarcation of municipal boundaries and the delimitation of wards has got its own problems, and people fight over these things. And if we delay doing what is expected of us under the circumstances, we are also contributing into that particular problem that can be experienced in the future. And my view is that let's bear that in mind. Let's bear that in mind. Let's be realistic. Let's try our level best to ensure that we finalize this particular process. If, as I said, if we can't, we will accept that we can't. But I think we need to give it an effort that it deserves, and at the end of the day, and that we do what is expected of us. Our term of office as members of Parliament ends the 29th of December, of May, and Parliament will be dissolved, if that could be is the right word, on the 21st of May. And in the meantime, we must do our job under the best circumstances that we have. That's how I look at it. I want Parliament to respond to this, and thereafter have some few discussion, and as a way forward of saying, under the circumstances, what is it that can be done to salvage the situation? Over to you, Legal, based on the questions which were asked by honorable members.
Good afternoon, Chairperson. Chairperson, my input will purely be a legal one, and I think that's what I've come to make in the committee. Honorable Sheikh has asked me a question regarding whether this process can be open-ended or not. And Honorable Sheikh, if you look at the Limpopo letter, if you can be practical, which was written to the committee on the 26th of February, to the chairperson of the NCOP on the 26th of February, 2024. All it does, it seeks a 2 weeks extension. Now, if you look at even our own instrument, which is the 10th edition of the NCOP rules, sub-rule 2 says, depending on the substance of the bill, the period for the consideration of the bill is at least 8 weeks. Now, if you look at the fact that in Limpopo, for instance, the public hearing, the briefing by the department took place on the 19th of February. And if you can compute 8 weeks from there, you'll agree with me that it will end on the 19th of April. I'm just being practical here. I see that in the case of the Eastern Cape, for instance, the Eastern Cape, all it has said is it has even given the chairperson its own program of the matters that are serving before it. And all it has requested is that it cannot process this before the 31st of March, 2014. And sub-rule 3 of our own instrument as Parliament says, in the event that the substance of the bill requires more time than the 8-week period, the chairperson of the council may, at the request of the chairperson of the relevant committee or speaker of a provincial legislature, extend the period. So even our own instrument in the circumstances allow for this period. The provinces themselves have said this time, is not adequate. And if we read, even if we look through our own instruments, which is the rules, in this instance, our view as legal services is that what these provinces are asking for is not unreasonable. And therefore we say that unreasonably withholding the said request has the danger of opening us up for unnecessary and costly litigation. And we're basing this, for instance, on Mukhale. Mukhale was pushed through, it was passed, it was signed into law and so on. And only afterwards, when we were taken to court, we had to start the process afresh. So all we are saying, Chairperson, is that the requests as they stand in front of us, I wouldn't agree that they are open-ended. That is just my view. Because Limpopo said 2 weeks and the Eastern Cape said, given the program which we've given you, we can't do this earlier than the 31st of March. So, Chairperson, I'm saying even if we were to compute, 8 weeks, which is indicated as the least period in terms of Rule 219, Limpopo, for instance, is still within time, Chair. And I think, Chairperson, if we listen to what Honorable Smith said, for instance, that the programming will end on the 25th of May 2024, Chairperson, it appears to me that reasonably so, Chairperson, we can be accommodated. We can be able, to accommodate these provinces. And Chair, in Doctors for Life, the Constitutional Court has said, in setting out factors to be considered in determining whether public involvement is reasonable, it has said the nature and importance of the legislation and the intensity of its impact on the public are especially relevant. It has gone beyond that to say reasonableness also requires that appropriate account be paid to practicalities such as time and expense, which relate to the efficiency of the lawmaking process. And the point has been made, that time in itself does not justify inadequate opportunities for public involvement. Chairperson, now I won't take it further.
Thank you very much. In essence, what are you saying? We give them extension of 2 weeks.
Yes, Chairperson. Yes, Chairperson. Chairperson, all that I'm saying is that the request for 2 weeks by Limpopo Chair, in my view, is reasonable, Chair. And I'm basing it, Chair, on when was this transmitted to them, and of course, when did the department conduct the briefing there? And in the slide that I've been referring to, Chair, from the department, it's not indicated there as to when did the department do its briefing in the Eastern Cape, Chair. And I think if Dr. Naitu can assist me with that as well. Okay. Yes.
No, it's okay. No, it's okay. Honorable members, under the circumstances, can I propose that we, in line with the rules of the NCOP, write a letter to the chair of the NCOP, request an extension of 2 weeks, allow these 2 provinces to finalize. In the meantime, I do the same exercise of engaging with these 2 provinces. Immediately after this, maybe elevate my engagement with the provinces to the speakers of the provinces so that they finalize their negotiating mandate. In the meantime, we have received the responses from the department on how they have responded to the negotiating mandates of the 7 provinces. We are not, I propose that we should not proceed today in terms of the discussion on each and every province. We suspend that until 2 weeks when we receive, or presumably we would have received, the negotiating mandate from Limpopo and the Eastern Cape. And then based on that, we will be left with the final mandate and try to drive the process under the circumstances. I propose that we do that. I don't know. I want to hear your view on that so that we take a decision about what needs to happen. Honorable Sheikh?
No, thank you very much, Chairperson. Chairperson, I can't help but agree with your proposal that we actually give the two outstanding provinces 2 weeks to then finalize the negotiating mandate. And then as a committee, we would then further deliberate on this on the bill. I understand, Chair, that we are going on recess, but I would propose that we get the responses by the departments on those submissions as well while we are on recess. Thank you very much.
Honorable Chairperson. Chairperson.
Hello, yes.
Yes,
Honorable
I want to
Badenos?
check Honorable Bartlett.
No, let me give Honorable Badenos first.
Thank you very much. I just want to also make sure we place on, because legal didn't refer to this letter that the Western Cape Provincial Legislature Speaker sent on the 15th of February to Honorable Masondu to bring to his attention that there was a deficit in the public participation in the Western Province, and to request for an extension, and that extension requested was until the end of April, or let it stand over for the next administration. Now, the reason, I think one of the reasons that extension has been requested, because if you look at our own rules, our own rule says 8 weeks. Now, if we only received the briefing on the bill on the 13th of February, 8 weeks from that will take us roughly to the middle of April. But Section 2193, Chair, says that if a speaker of a provincial legislature writes a letter requesting, due to the substance of the bill being so serious, as you've alluded to, request in writing that the chair of the council may extend that period even further than 8 weeks. So I'm just worried that we're going to be, even with a 2-week extension that you're now proposing, that we'll still be outside our own rules with regards to the timeframes. Thank you, Chair.
Okay. Yeah. If you don't mind, can I also elevate this letter to my discussion with the chair of the NCOP to say, how do we respond to this particular letter under the circumstances, bearing in mind that irrespective of the time constraints that we have, 7 provinces have submitted their negotiating mandates, and what do we do under the circumstances? For me, end of April is a bit awkward because after receiving the negotiating mandates, it's not the end of the story, if I may put it that way. We've got to discuss, consider the submissions from provinces and the response from the department. Thereafter, refer these matters back to the provinces for their final mandates. And at that time, we will be in the middle of the elections. We will be left with about 3 to 4 weeks before the elections, and it could be very, very difficult under the circumstances. I suggest that we work on what we have. I will engage the chairperson of the NCOP in relation to the letter of the Western Cape and develop an appropriate response to it, and develop a way forward about what needs to happen, given the time constraints and the difficulties that we find ourselves in as the NCOP, as this committee. I've expressed this view over and over and again to say the most difficult part of lawmaking, it is when matters rest with the National Assembly, they come at a later stage to the NCOP, and we are expected to rubber stamp. And we are not a rubber stamp, we are an independent house that must do its work. We need more time to consider this, especially when it is Section 76 legislation. It follows this process that we find ourselves in. It's a laborious process. It's a very serious process. It's an intense process that requires meaningful participation. And provinces are unique, and we've got to respect that as well. And there's a difficult that I've raised over and over again about how processes must unfold at the level of the NCOP. But be that as it may, I propose that this is how we must proceed forward. I will engage the chairperson in respect of the 2-week extension for the 2 provinces. 2, we will discuss the letter from the Western Cape and its implications. 3, as soon as we receive the negotiating mandates from these 2 provinces, we will request heartily the department to give responses. And at that point, when we discuss, we will discuss the responses as part of the whole package of the 9 provinces. And out of that, I believe we will develop the final mandates to the provinces. I think this is how we must sum up the discussion. But I had the hand of Honorable Martha Bartlett, who wanted to say something. Over to you, Honorable Bartlett.
No, they already covered me, and I also wanted to second the proposal that Honorable Sheikh made, Chair. But
Okay.
the current others. Okay, Chair. Thank you very much.
Okay, wonderful. Honorable members, I think let's adjourn the meeting on that note that this is an important process. Unfortunately, one of the biggest lessons that we must learn out of this is that the NCOP always is put under pressure, and we are not an appendage. I've said this repeatedly. We are not an appendage of the National Assembly. We are a house that must do its job. If in the past people were allowed to do these things, it cannot happen now, because we've got to be diligent, we've got to be meticulous, we've got to do our job independently to the best of our ability as a House of Parliament, especially when we link up with provinces, especially when we link up with municipalities and expect their contributions in all these particular processes. And we need that sort of space and independence to look at matters quite appropriately with sufficient time at our disposal. And there's a matter, in my respective view, that we must continue to raise in respect of the role of the NCOP. With that, thank you very much, honorable members, and the rest of the officials, especially officials, for your support, your guidance and counsel in respect of the matters that are before us. We always rely on you, and we take your views and proposals into consideration. Thank you very much. The meeting stands adjourned. Until we meet, we will spell out in precision how that is going to happen based on the work that we are going to do. Thank you very much. The meeting is adjourned.
Thank you,
Chair,
Chair.
Chair.
Thank you.
Thank you,
We are
Chair.
so happy that sanity have prevailed.
No, thanks, Chairperson. Go.
Recording stopped.